So, welcome to the third session of the fourth workshop on terrorism and belligerency, human enhancement and advanced technologies of the Minerva Center for the Rule of Law under Extreme Conditions at the University of Haifa. This is part of the Young Researchers workshop that we're doing in the last days. And we're having a lot of interesting presentations and very, very lively discussions. You can find all of previous presentations and also future presentations if you're watching that in a few days from now on our YouTube channel. The presentation and the sessions, like all of our sessions, are live streams and recorded. They're live streamed on Facebook and recorded and will be uploaded to our YouTube channel, which you can find. Just search for Minerva Rule of Law under Extreme Conditions. In today's sessions, we're going to have two presentations and respondent to each presentation. Each presentation is going to take place between 20 to 30 minutes, and the respondent will be in between 15 to 20 minutes. Following that, we will open the room for open questions and Q&A from the participants and also from the audience if you would like to ask questions. Okay, so let me introduce today's speaker and respondent. Today's speaker is Zeno Suller. He's a PhD student in Hungary at the Peter Pázmány Catholic University in the Department of Public International Law. His field of research is international criminal law and state responsibility for the most heinous crimes, with special regard to the modern forms of terrorism. In the past, he has participated in the International Criminal Court competition in The Hague, which make me think whether or not he participated against my own students, by the way, and also humanitarian law moot court competitions in Ljubljana. He holds lectures and moot court preparation courses at the university where he does his PhD. The respondent is Professor Amnon Reichman. He's one of the PIs of the Minerva Center. He's also the director of the Center of Cyber Law and Politics at the University of Haifa. His specialty is public law, especially constitutional and administrative law, and his areas of expertise among the includes also models of regulations and neo-institutionalism. You have to decide how to say that word, it's too long. Separation of powers, theories of judicial review, human rights, and comparative constitutional and administrative law. And if I have to be honest, and I don't have to be honest, but I want to explain that, Amnon is usually one of the best respondents we have on the workshop and on our seminars. And Zeno, you are in for a treat, and Amnon is blushing at the moment, apparently. Zeno's presentation is going to be on the topic of the rule of law when fear rules, an interdisciplinary study on technological advancement and international norms on terrorism. After that short and nice introduction, Zeno, the floor is yours.
So thank you for this opportunity. Contrary to the other papers and presentations, my paper and my essay is rather general, and it is rather an overview on technological advancement and its potential use in both terrorism and counterterrorism. And of course, it also elaborates on how international law may respond to this new reality or to these challenges. And now I should, okay. Next slide. Of course, it's the way of introduction. It is important to state that our perception to technologies seems not to be so up to date. So for instance, in the case of robotics, we tend to think that robots are these funny, rather clumsy machines which have resemblance to human beings. But in reality, their cognitive and operative functions are so advanced that in many fields they can perform better cognitive and operative functions. And the problem is that it's not only our psychological and mental awareness which is not so up to date, it is the legal environment as well, which seems to be not so updated to the challenges. And it is even more a realistic problem in the case of public international law, which evolves rather slowly. So I built my paper on 2 blocks. And interestingly, although I'm a lawyer and this paper is rather a legal evaluation, at least half of the paper talks about technology and its potential use in terrorism and counterterrorism. So the first part is basically the material reality of technology, and it involves 3D printing, synthetic biology, the usage of drones, and social media, deepfake, and machine learning. And the normative reality deals with the international rule of law, which has 2 pillars concerning terrorism. The first one is international criminal law to hold responsible the individual perpetrators, and the other pillar is state responsibility for the heavily debated notion or term of state terrorism. So the first technology I observed is, for the first sight, it may seem that this is the least interesting technology, but in my view, it has the most potentials, both in changing our everyday life and in committing terrorist attacks. So AM technology is 3D printing, and the abbreviation stands for additive manufacturing. The name suggests that these printing machines do add layers upon layers of usually matted substances or materials. This evidently enables the machine to create products in a customized, individualized way. So it can create really peculiar shapes as well. But considering the fact that these machines are basically robots, they need a CAD file, a computer aided design file, a blueprint or a build file, upon which it can create the desired objects. And these blueprints also make the production able to be standardized. And AM machines can use a wide range of materials. The most evident one is, of course, plastic, but it can print metal, alloys, and even ceramic. And the fact that this AM technology is both customized and standardized, and the fact that raw materials are rather easy to obtain and apply because they are basically pastels, it has a huge potential to use in everyday domestic households, for instance, with hobby AM machines. And this potential is presented by Cody Wilson. Cody Wilson was a law student in Texas, and he considered himself as a human rights activist. He stood up for the right to bear arms, and he created a blueprint, a CAD file basically, of a handgun, which were printed out of plastic materials. And there was just one element which was metal, and he used a simple domestic needle for that part. And all the other parts were made out of plastic, printed at home with his AM machine. But being an activist, of course, he also shared his idea and the blueprint with others, and he uploaded it to the internet. And now the Liberator, which is the name of his plastic handgun, is available to everyone, and someone may have an AM machine and can print it at home. This is a fully functioning handgun, by the way, and it is not detectable with metal detectors, for instance, so it can cause some problem in security. And considering the fact that it was not produced in a legal way, it was designed and printed out at home. It is not registered, therefore it is not under the watchful eyes of the authorities. Therefore, it enables non-state actors to print their own handguns. In the near future, it may cause a problem, especially concerning commissions of terrorist attacks, which are classic in Europe, shooting in public places, for instance. But it's not only this problem which is caused by the AM technology, because AM machines can actually print more materials together. So it can create Kevlar or metallic glass or graphene or boron nitride. These are new and artificial materials which have the qualities which are much better than, for instance, the ordinary metal or alloy materials. So they are excellent for creating weapons of mass destruction. And the problem is, of course, that although developing, storing, and deploying weapons of mass destruction is usually attributed to the states, or at least private companies in strict connection with states, the fact that AM uses blueprints and most of the areas are connected somehow to databases, it is possible that hackers can, for instance, access to these blueprints and make it available to terrorist groups as well. So all these points to one direction, that the weaponry may be produced and used by non-state actors, and the usual protective measures like metal detectors or registering the handguns or issuing certificates for those who can bear handguns now fall out of the potentials of the states. And there's another field which may fall out of the exclusivity of states, and this is biological research, especially in the field of synthetic biology. Synthetic biology basically means artificial biology, so redesigning already existing living organs or actually creating never existed biological structures. The first such research happened in 2002 when a group of researchers created the polyvirus. The polyvirus was extincted back then, so they created the exact copy of the original polyvirus, but out of the pure chemical components of the virus. It means that they reached cell proliferation without a parental genome, without the original virus itself, only with the oligonucleotides. These are DNA segments, which are also made out of pure chemical substances. And evidently, it means that it creates a potentiality to create new pathogens, to create new viruses, and it can cause some problems considering bioterrorism. And if we add the fact that 3D printing also enables to print living organs like tissues, it opens to a really frightening future when even viruses or living tissues can be printed. Therefore, biological weapons are easier to develop in the future. If you look at the picture, for instance, you can see the ear of Van Gogh. It is not the original ear of Van Gogh, which he cut off, but this is the identical one considering his DNA. This ear was printed with a bioprinter, with a bio 3D printing, using human tissues, and now it sits comfortably in a nutritious substance. A less shocking and more familiar technology is to be the drones. Everyone knows them. They are really mobile, agile, and you can buy them almost everywhere nowadays. But even if you do not add anything really advanced to the already existing drones, it can be really useful to terrorists. If we consider how the classic terrorist attacks are planned and perpetrated in Europe, for instance, you can see that it was really a dangerous activity. It was a suicidal mission to commit terrorist attacks, because evidently one had to cross the security checks, had to spot the best location where there is a dense, where there are many people without many exits. And when the perpetrator commenced the attack with shooting or with explosive substances, it evidently meant that the terrorist will die or at least be captured by the authorities. With the help of drones, this can be quite different, because from distance he can evade the security checks. He can spot from above the best location to apply the explosive substance, for instance. And evidently, it does not mean that it is a suicidal mission. Therefore, the psychological effect of using drones in such commissions means that more and more people will be encouraged to do such terrorist attacks, because it will not mean the end of the life of the perpetrator. One may argue that one possible solution is to register all the drones which are available in the stores, for instance. But the problem is that combining drones with AM machines, 3D printers, it will enable the perpetrators to create their own drones, which means, of course, that they will not be registered and they will not be monitored by the states. So therefore, the perpetrators could remain in the shadows until the commencement of the terrorist attack. But sometimes it is rather the interest of the terrorist to get out from the shadow and to spread their ideology and to spread intimidation. And social media is the best source, or the best place to spread hatred and to recruit new members to the terrorist organization. So there are two messages which are to be delivered to the recipients in the social media. First of all, the terrorist organs need to have new members, and spreading extremist ideology can help to recruit new members who consider themselves outsiders in the society they live in. And algorithms help a lot to terrorists in this context, because algorithms tend to narrow the interest of the user. So it enables them to search for more extremist and more violent contents, and therefore pushing the user to more extremist groups. And it can result that one day the user will plan to commit a terrorist attack, for instance, in Europe. The other message the terrorist groups would like to deliver is intimidation, because of course the intent of a terrorist attack is to intimidate the civilian population. So for instance, by broadcasting massacres or to broadcast killing of journalists, evidently it creates fear, and due to the freedom of internet, it is really easy to upload even a violent content. And even if it will be deleted, it's really hard to delete all content from the internet and to regulate every aspect of the internet. Deepfake in itself may not pose a huge threat, but in the mission of the terrorists, it can be a valuable asset. Deepfake is a synthetic media, therefore it creates content in an artificial way. If you provide training data that is input, for instance, a face or a sound of someone, it converts it into data, and from that data, it can create an artificial content. Evidently, this can help to break solidarity and consensus between the members of the society, and it can spread uncertainty, disinformation, and confuse, which will help both recruitment and intimidation for the terrorist. But society is not defenseless, of course. For instance, in the social media platform, Facebook, Instagram, Twitter, and YouTube, algorithms help the operators to filter those contacts which are to be considered as violent or aggressive or hateful. And it works in a way that it's rather automatic, so it is not perfectly accurate. It means that those phrases and notions which usually refer to terrorist attacks or encouraging violence are deleted. It also means that, for instance, sarcasm or irony is the victim of such an automatic filter, whereas if a terrorist group phrases its message in an indirect way, it can mean that it will not be deleted because the algorithm may not be able to identify it as a threat. For the authorities, big data may be the best tool to combat terrorism. Big data can help to prevent terrorist attacks It can help to investigate already happened atrocities, and it can help to arrest the perpetrator or to provide evidence during a criminal law procedure. Big data is a huge amount of data or databases which consist of data which are changing, which have different sources. So it is a set of large, dynamic, and variety of databases. So for instance, the competent authorities may know about the social media presence of the perpetrator, the emails, the phone calls, credit card usage, GPS data, and any other movement of the perpetrator which connects to a data, which are connectable as data. Evidently, it also means that those persons who are not involved in the perpetration will have to face the lack of privacy, because, for instance, street surveillance camera footages record everyone on the streets, not only the potential perpetrators. Machine learning can provide the improvement of both algorithms and big data, because machine learning is basically the cognitive function of a machine. It enables an analogical thinking and an autonomous improvement for the algorithms or the big data. So it can analyze, identify, and categorize between objects, between data, between sounds or events, and it can make decisions afterwards. So to move on to the legal part of the paper, it is evident that the infrastructure and the technology can help counterterrorism, to combat terrorism, but actually law is needed in this battle, because law is the most powerful protective tool of the society. First of all, it enables the authorities to resort to technology and to infrastructure, and secondly, law enables the authorities to hold accountable those ones who are responsible for the terrorist attacks. Law is most effective when it is part of the principle we call the rule of law, so that law is to be respected by all actors, be it the state, be it the non-state actors, or the individuals. But it's also important to state that the law which is to be respected cannot be any norm. So it cannot be the ad hoc order of the power. So the law must respect certain substantive and procedural guarantees, like, for instance, human rights. At the domestic level, the rule of law is needed because there is just one center of power, and not to abuse this centralized power, the rule of law can help the individuals and civil society. At the international level, the problem is rather different, because in this case, there are too many sovereign powers, and all of the sovereign states consider themselves as the utmost authority. So to respect the international legal order, international rule of law must be present. So the international rule of law in connection with terrorism can be based on two fields or two domains of international law. To prosecute the perpetrators, the individual perpetrators, international criminal law can help. And the other pillar is state responsibility. State omission means, of course, that the states should prevent and criminalize terrorist attacks. And what is more important here to challenge is the notion of state terrorism, because in today's contemporary legal framework, state terrorism is not really a legal definition. So as for the first pillar, the ICC, the International Criminal Court, was set up to put an end to impunity and to provide legality. Because before the International Criminal Court, there were ad hoc international criminal tribunals, and then the principle of legality seemed a bit in danger, because it was inevitably a kind of retroactive effect. But the problem is that under the Rome Statute, which is the criminal code basically of the International Criminal Court, terrorism is not a crime under the jurisdiction of the ICC. And it is because the states deliberately left out terrorism from the Rome Statute, because they thought, that argument was at leleast, that the oddidere ut iudicare principle is sufficient enough. It means that these states should cooperate in terrorist actions, for instance. So they either prosecute the individuals or they extradite them to the other state. In reality, I think why they left out terrorism is rather because it is a political notion, and states tend to politicize the notion of terrorism. But I argue that even if terrorism is not an international crime per se, the action itself, the actus reus, may be prosecuted under already existing forms of crimes under the jurisdiction of the ICC. And therefore, at that point, I needed a definition of terrorism. And I used the definition in the Convention on the Suppression of the Financing of Terrorism, because the other international agreements on terrorism deal with special, peculiar forms of terrorism, and only this convention provided a general definition added to the already known specific areas. So the three main elements of terrorism should be the conduct, which must be a violent act, the result, which is the death or injury of civilians, and the intent to intimidate the civilian population or to compel a government or an international organization to do or not to do something. If we consider the elements of crimes against humanity of other inhuman acts, which is the most adequate crime to prosecute terrorism, we can see that most of the elements overlap. So crimes against humanity of other inhuman act under Article 7.1k needs an inhumane act, which resembles to the violent act. It must cause suffering or serious injury to the civilian population, which equates to the result of terrorism, which is death or injury to civilians. And it must be widespread or systematic. Widespread means multiple commission, whereas systematic means being part of an organizational policy. In case of terrorism, we can state that in most cases, even individual perpetrators are connected to some kind of organization, and we can say that there is some kind of policy behind the commission. One problem is present here, however. Even if the conduct itself and the result can be attributed as crimes against humanity of other inhuman acts, the intent will not be evaluated in that way. And it is problematic because there are crimes which are to be considered as intent crimes. Like, for instance, genocide is an intent crime. So without the genocidal intent, it cannot constitute genocide. So this is a problem, and this is why maybe criminalizing terrorism as a new international criminal crime would be more sufficient than prosecuting it under crimes against humanity of other inhuman acts. And I think I still have 5 minutes, which leads to my last part in the paper. And this is the other pillar of the international rule of law, state responsibility for terrorism. I mentioned already that the problem is that in the contemporary legal framework, states do not commit terrorism. It is not accepted that the term state terrorism exists. It is because it is the states who determine what terrorism is, because they form public international law by customary international law, concluding agreements, or their activity in international organizations. So basically, they decided that terrorism can be committed by non-state actors and individuals, but not by states. The state may be responsible for an omission if it's not prevent, investigate, or prosecute a terrorist attack. But basically, a state cannot commit terrorism. But if we put aside the legal term and we look for the notion of terrorism empirically, we can see that actually originally, terrorism was attributed to states. It was first used to describe the regime, the Jacobin regime of the French Revolution. Therefore, terrorism was attributed to states. Later, it was attributed to anarchists, assassins, and nihilists, therefore individuals. And after the collusion between Ireland and Great Britain, and especially after September 11, terrorism was attributed to non-state actors, like terrorist organization. So empirically, we can say that terrorism could be and can be committed by states, individuals, and non-state actors as well. So at that point, now we have to define what I mean when I say state terrorism. State terrorism can mean that in an international dimension, a state uses force against another state. It can mean that within an armed conflict, state can resort to violence and intimidation. And it can also mean that a state internally uses violence to intimidate. At that point, we can see that international law is not without possibilities, because, for instance, when a state uses force against another state, it can be called as an internationally wrongful act of aggression. IHL, international humanitarian law, can deal with issues within an armed conflict, be it an international or a non-international one. But outside the international context, if state terrorism is realized internally, domestically, then it seems that only jus cogens or human rights norms may be applied. So what I mean by internal state terrorism, it basically means the intimidation of subjects, imprisonment of journalists, using violence against protests. So basically intimidating and using force against its own citizens. So basically, internal state terrorism means autocracy. But autocracy is the fundamental structure of a state. So it is the political, economical, social, and cultural system of a state. Hence, it is the internal affair of a state. And international law cannot really intervene to internal affairs. There are some aspects which can be evaluated, like, for instance, jus cogens norms, if they are breached, or international human rights, universal human rights. But the system per se, in itself, cannot be challenged by the international legal order. And the point is that internal state terrorism is an autocracy. And in fact, autocracy is the lack of internal rule of law. And the problem is that the international rule of law cannot enforce the internal rule of law. And this is why my conclusion is that although there are possibilities to evaluate some aspects of state terrorism, and although there are possibilities to criminalize some aspect of terrorism committed by individuals under international criminal law, it seems that it's not really enough, and it does not really cover all aspects of terrorism, especially considering the technological advancement. Because technology means that it will be more available to everyday usage, to individuals as well. If you take the computer or the internet, it was used by military, but very quickly it got to the everyday usage. So individuals will use technology, and it will spread the terrorism to an international and global level. And it is the state who are the most potent actors internally and internationally, and it is most likely that states will abuse technological advancement. Therefore, and I conclude my saying, terrorism cannot remain a political issue, and both international criminal law and international rule of law should deal with this issue. And I argue that a new regulation is needed in this respect. Thank you for your attention.
Thank you, Zeno. That was very, very interesting presentation. And now we turn to Amnon for his response.
Thank you very much. It was indeed a very interesting presentation, and I enjoyed also reading the paper. So the paper posits a question related to what could be defined as disruptive technologies. So disruptive technologies are those technologies that disrupt in the sense of changing, drastically changing the way we do things by introducing novel ecosystems. They are disruptive also in the sense that they can be misused and cause great disruption in the sense that fundamental values, fundamental rights may be infringed. And therefore, the question is, with respect to disruptive technologies, do they also disrupt legal technologies in legal concept, legal procedures, and legal institutions, and therefore call for, as Zeno concluded, new regulation or not? And here, the paper gives 4 examples that Zeno just touched upon. It talks about AM, it talks about bio uses, talks about drones, and it talks about deep fake and AI. You could have also, Zeno, mentioned other potential cyber terror, cyber crimes, penetration to computers, the disruption of financial data. There are lots of potential disruptive uses of technologies that fall outside of the 4 examples that you gave. But I think that that's fair because you didn't try to be exhaustive. You didn't try to give all the potential uses of terrorism. So you just gave some, which are good. That's great. I'm not sure that you necessarily gave the most serious ones, because I think that the most, at least in the short run, the idea that individuals may hack into systems and fully disrupt these systems could count as terrorism as well. You don't have to print guns. You can just take over cities or take over banks or take over critical infrastructure, and that would count as terrorism as well, just an addition to your list. But as you mentioned, technology is also part of the solution. And I think here you downplayed a little bit the role of technology. You seem to rely on the notion of licensing. Now, licensing is an old 19th century technology through which the state regulates, but you don't need licensing to use technology to regulate. For example, you can detect, if you want, any broadcasting device because it has something unique to that broadcasting device, either a MAC number or some other numbers. Even if you don't identify the specific device that broadcasts, you can use technology in order to disrupt drones if you want to. So the state can say, if it wants to, I'm going to disrupt using broadcasting or using technology, I'm going to disrupt drones like that if I want to. So I can broadcast some electronic signal that will disable the operation of drones if I want to do that. That's just an example. I can also detect, if I want, the use of bio instruments, because I have surveillance techniques, if I want to, that will track potential uses. I can also, as you mentioned it with respect to the possibility of the social platform themselves, but the state itself can monitor, detect, and analyze all bits if it wants to, at the level of the individual bit, because the state has access to the infrastructure of networks. I'm not saying it can be complete. I'm not arguing that there won't be instances whereby individual acts of terrorism could happen. But I am saying that if, on balance, if we look at the problem, that I wouldn't necessarily suggest that the problem now is essentially the fear of this terrorist cell or those individuals printing handguns or using some biological tools. I would think that at least an equal concern is state control that is used in order to protect against misuses of technology. If something I think that the security establishment now has much greater powers and can penetrate and know almost everything about us, so that it can, as an aftermath of 9/11, right? So it can prevent future acts of terrorism or state terrorism, whether we accept this term or not, or individual terrorism, or just by individuals, or let's say organized terrorism, which is an in-between. This is a terrorism that is done by organizations. So I think the security establishment, if at all, has its disposal great powers. And I think that in any analysis of that, and you mention it in your paper, that we have to protect against human rights, but I think the starting point should be, this is the greatest concern if we care about autocracy. The greatest concern is that states are becoming more and more autocratic in the name of preventing terrorism. Now here you make an interesting leap, and I'm moving now to the second part of your paper, and that is about the law. And you say something very interesting. You say law is the most powerful tool against deviance or dangerous violations of, and this is interesting. I think that us lawyers would like to think that law is the most important or powerful tool. But I'm not sure that, that all will agree that we should start with the law, or we should ascribe to the law this primacy. I certainly agree with you that the rule of law is fundamental, but we should say something more. If you want to, to the extent that you rely on the relative power of law versus other systems, or the relative importance of law, then you should say something about it, because it's unclear whether the law is the main player here rather than technology or the market or other political incentives at all. Now, if we talk about the law, then the starting point is not necessarily international law. And I will go back to this point when I will conclude. You sort of jumped to international law because this is what you want to talk about. And that's okay. But if we talk about the legal regime more generally, we don't jump straight to international law. If we are international law, I think a starting point is not necessarily criminal law, or the ICC, which is, as we all know, the complementary dimension there. If all else fails, then okay, we have the Rome Statute and we have the ICC, and we know empirically that the ICC, it was not designed, nor can it operate in order to meet the challenges that you stipulate, because the challenges you stipulate are not the challenges of, once in a lifetime or whatever, 15 prosecutions a year or something like that. The challenges that you stipulate require ongoing investigations and prosecutions, and I'm not sure that to build too much on the ICC empirically, but also in the manner for which it was designed, is where we should start. It's the last full safe feature out there, fail-safe feature out there. It shouldn't be the starting point of the analysis. I think a starting point of analysis could be the Wassenaar arrangement or agreement, whereby you talk about the export and import of dual use. And you mentioned dual use, you mentioned biology and atomic materials in your paper. So the way you should start is the Wassenaar agreement that talks about the dual use. And recently it was updated to include also cyber. So that could be a more, I think, realistic starting point. I'm not saying it will help necessarily, but it's more realistic. And I want to focus now on the main point of your article from a legal perspective. That is the notion of terrorism. And the question is whether terrorism does the job, whether we need terrorism to deal with the challenges you stipulate. So you are aware of the great debate about what is terrorism, and there's an ongoing debate. So you make the move, which itself is not free from difficulties, to analogize first from ethnic cleansing and say, well, ethnic cleansing wasn't in the Rome Statute, so we can include cyber terrorism as well. But of course, it's different because ethnic cleansing is closely related to genocide, in the sense that the international community as such has a role to play in defending some ethnicities, whether they're defined as that which could be exterminated under genocide or not. So it's closely related to genocide, more so than cyber terrorism. Now, and then you make the other move that says, well, even though they decided against it, we can still find a definition from cyber finance for terrorist finance of terrorism. But then again, the point here is that in finance, the harm is different than the actual terrorism. And so some would say the very fact that they decided to focus the treaty solely on finance and not on the actual use of terrorism could go the other direction. And we know that it was a conscious decision not to include terrorism in the definition of the Rome Statute. And then they have issues of interpretation. Does travaux préparatoires count, and the intent of the framers, et cetera, et cetera. I'm not going to talk about this because there's a lot of literature in the international law about that. What I do want to talk about is whether you actually need terrorism. So you need terrorism. But why would you need terrorism at all? You can say, well, if state uses technology in a way that violates international norms, go against the state without terrorism. You don't need terrorism if it's a crime of aggression, if it's a crime during war, then if it's a war, it could be a war crime. There are, as you mentioned in your paper, there are other tools. You wouldn't necessarily catch everything, but even if you catch 80%, that's good enough. Now, you could say, but I have the problem of the individuals. I need the definition of terrorism to capture individuals who commit those crimes. And this is why I need Rome to do this. Now, so here you have a bit of a tension in your paper, because you talk about state responsibility. Now, state responsibility could be understood as two. So there are two opposing terms here. One is state liability, in the sense that the state is liable, and the other is state responsibility in the sense that it empowers the state. The law empowers the state because it is responsible to do certain things. A lot of debate about that. I want to suggest that one way to look at this from an international law perspective, and I'm almost ending my comment in order to allow time for questions and answers. One way to look at it is to look closer to the institution of sovereignty here, and to suggest that international law could be relevant with respect to individuals. If individuals commit crimes, cyber crimes that amount to terrorism, in two ways. One, you can say it allows us to penetrate the shield of sovereignty to the extent the state fails to protect its own citizens, and then it has a duty to protect that will then provide legal basis for humanitarian intervention. So if there's a great flood and the state fails to protect its own citizens, well, maybe we have a duty to penetrate the shield and help these citizens. If it's just a flood, let's assume that the state fails to protect its own citizens against cyber terror, or itself uses those tools, as you stipulate, against its own citizens. Maybe we can devise a regime that allows external bodies to intervene and penetrate the shield of sovereignty, because you cannot use the shield of sovereignty that stems from right to self-determination in order to undermine self-determination. So again, that goes back to the notion of social control. If, or to the extent that technology is used to undermine the ability of a nation to self-govern, then maybe other nations have a duty, or at least have a right, to penetrate the shield of sovereignty of that particular nation and allow and remove the terrorist aspects that prevent self-determination. That's one possibility. The second possibility here is to say, yes, we are going to go for those individuals to the extent it's not state-based. Let's say that you talk about the individual who commit terror and the state fails to protect, but the state is not liable for such failure. Then you can say, well, maybe we can use international courts. And I'm not against it, but I think that, and this is, as I said, this is my main point, by skipping over other national courts, some equilibrium is lost, because we all know that this is a residual instrument, right? You're not supposed to go there first. And I've always wondered, that I'm not going to talk about universal jurisdiction to a great extent, but I've always wondered why we think that the ICC, and you mentioned it, is more objective than other national courts, especially terror is politicized itself. I'm not so sure about that. I think that the countries or the states, the jurisdictions that actually care about terror are those that care about human rights. So the institutions that care about or the jurisdictions that care about human rights, generally speaking, should not be sidestepped before we go to the ICC. That's what happens in reality, because of the nature of cyber terror or the use of technology, which crosses jurisdictional boundaries by definition. There is a transnational element here by definition. Other nations cannot remain in inert, passive. Other courts, in real life, this is what happens. Other courts will tell you, okay, if you produce these weapons in other jurisdictions using those printers and then you import them to me, that's a crime, the national level. And therefore, national courts, that's, I think, the key concept here. National courts play a huge role in developing, you call it state practice or norms. That's the layer that is missing. But, and that's my final word, I'm not sure courts are the ultimate solution. We lawyers tend to think about courts, and therefore we have this, courts will be there and courts will save us. I actually think that we have a problem. The main problem we have now is different. It's within the executives. Executives cooperate all the time with respect to cyber terrorism. They exchange information, and they're on to it. They have to. The question is, what is the cultural DNA of those executives? And that's not a legal question. After the Second World War, there was a cadre of people in the security establishment that said, oh, we saw what just happened. Maybe we should have internal checks and balances within the executive. I'm not sure. I think that post 9/11, at least with respect to cyber terrorism, the idea is if we have to err, we will err towards overprotection and not underprotection, which causes the problem of great fear of social control that I talked about before. We should develop, therefore, legal, not just cultural, legal mechanisms, watchdogs, other forms within the executives that will check the use of states with respect to the cyber technologies, but will also supervise the rise of terrorism, because terrorism always happens in a jurisdiction. It never happens outside of a jurisdiction. So if it happens in a jurisdiction that protects or looks the other way, then those executives already form coalitions. We have to make sure that they don't discriminate, that they treat all cyber threats equally. If we achieve that at the state-to-state, transnational level, I think that will be a necessary stepping stone towards the international regime that you talk about. I conclude with that. Thank you.
Thank you, Amnon.
Can I just add some response? But thank you very much. This seems enough comments to write my dissertation. There's one aspect which I'd like to react, because I completely agree with you that the first step should be the national courts and the national jurisdiction. The reason why I did not elaborate and I did not even write down this this important stipulation is because I was interested in the international affairs, but this is a fair comment that it must be at least indicated in the paper that this is the first place. But actually, I think that although national courts and national jurisdiction is the first step, I'm not sure whether they are more objective or as objective as the International Criminal Court can be. So I think that the ICC should have jurisdiction in some cases, but in a residual or complementary way, of course. But for instance, after September 11, I'm not sure whether the response of the United States was objective, and I'm sure that it was rather motivated by revenge. And the way the ICC works is that there are some cases when the national jurisdiction tend to be motivated by revenge or tend to be more sensitive. And in these cases, it's maybe more appropriate to find a hybrid or an international jurisdiction, for instance, the ICC. But I think this is an ultima ratio. So I absolutely agree with you. And it happens 2 times within 1 decade, I think. And that's it. I also agree with you that it is rather the executive level which should be first responsible to tackle terrorism. It is true, but the problem is that it is the executive which tends to abuse anti-terrorism measures as well. So again, this is a really productive way of communication, because it provides me a lot of topics to deal with my dissertation. And I'm really, really grateful for all the comments, and thank you very much.
I think we're going to start with João.
So just some quick comments. Again, I'm not a lawyer, I'm a philosopher, but some comments on the more on the technology side, and maybe some more moral questions about what you said. In the case of the printed guns, I think in some states the production side may be unregulated, but the use wouldn't necessarily be. Not that you said that the use would be, but in many U.S. states you can just go to Walmart with a driver's license and you have to have the right to buy a gun. So I'm not, but of course I'm sure that states are trying to regulate that, and having an unregistered gun you'll probably be some kind of crime. But I'm not sure if it is really completely sort of a thing that evades all regulations, especially in the US. And another thing would be that a local population could use in the future printing guns to have advanced weapons against a foreign invasion that is perhaps unjust or even just, but that's seems to be a factor in the future, that if this indeed becomes widespread and it includes advanced weapons, the sort of technological asymmetry between the local population and foreign invasion can decrease, or that can become an issue. And with synthetic biology, one thing to stress, and I think perhaps you mentioned that, but it's a lot easier to work with that than other potential weapons of mass destruction. And the accidental factor counts a lot too. After the smallpox was eradicated, which killed billions of people in human history, the UK accidentally released smallpox several times, causing a couple of outbreaks until it finally lost its smallpox license. It wasn't allowed anymore to handle that kind of a pathogen. And if even the labs of advanced nations can accidentally release this, imagine private citizens trying to do some kind of do-it-yourself work. So they might not even be intentional, but they are trying, let's see what I can do with this genome that is online. And then suddenly you release a vaccine-resistant version of, I don't know, even coronavirus, who knows. On the data network, one interesting thing to see with what is going on now with technology, would first, if there is any kind of updated impartial assessment of the role of social media in the Arab Spring. I believe the official report is that it helped enable, but it wasn't intentional. But it would be interesting to see how sort of evaluating this is going on. And maybe a philosophical exercise that I would like to ask, and maybe you could ask in your paper, would be assuming a similar scenario as the Arab Spring, but where we are sure there was intentional interfering by our foreign government. What would be the application of the law there? And another interesting current craze is the private hacker groups hacking government websites while they are based in unfriendly countries. So, for example, last year, the Russian hacking of US vital infrastructure, and not the same thing, but perhaps also included in this general category will be Western hacker groups attacking dictatorial governments' websites abroad. And we'll have to have some kind of consistent regulation here. And these things that under your criteria, it seems clear the hacking infrastructure will clearly risk widespread harm to this innocent civilian population. But it's still, I haven't been following the case lately, but until I saw there was no intent to prosecute Russia to fail to enforce its law against those hackers, or I don't know if it was Russia or some other country. In the case of state terrorism, I had almost exactly the same comment as your respondent said about intervening when states fail to act or even act violating the legitimate will of the people. And I also have sort of an amateur question. What about humanitarian interventions to stop ongoing human rights violations? To my understanding, that would be allowed by international war law, but perhaps I read too many revisionists in the area and I'm biased. And on the drones, I do understand that a state can disrupt all drones eventually, and as your respondent said, but the London airport drone incident 3 years ago lasted 3 days, sorry. And of course, we can overcome certain legal and technical issues given time, but it might take months and years to ground all drones without it being illegal or having side effects elsewhere. Perhaps the point here is that drones can disrupt the government too if they want to. Thank you.
For your comments and for the philosophical questions. By the way, just one comment to intervention, because I think you refer to humanitarian intervention or responsibility to protect, and actually humanitarian intervention is not lawful under international law anymore. If it was lawful, so a state cannot interfere to another state in a unilateral way by its own discretion. And I described the responsibility to protect in my paper, but actually I'm not convinced whether the responsibility to protect as a principle is a norm or has a normative value, because actually it was just accepted by the United Nations General Assembly, and it was planned to elaborate more on the question, but actually it was never developed into an international agreement or to any normative legal instrument. So I think that the only possibility to intervene to an autocratic state, for instance, if there are massive breaches of human rights or use against norms, remains to be the United Nations Charter under Chapter 7. So when there is a risk for international peace and security to be broken, I think that this is the only possibility to intervene when the Security Council decides so. I'm not sure about humanitarian intervention on the responsibility to protect. And I'm pretty sure that it cannot be individual states who interfere to such brave breaches of international norms. It's rather the international community itself with the United Nations Security Council. But again, I think it's rather political. It's rather a political organ of the UN than a legal one. Thank you very much for your comments.
The next comment, Agatha, please.
Thank you, and thank you for this presentation. As it is very interesting, especially that the state terrorism is a question that is very widely discussed nowadays, and it is so interesting. And it is also what my question is about, as I do not entirely agree with what you said and what you wrote in your paper about the state of terrorism. And because in your paper, you wrote that under international conventions, states are obliged to prevent and criminalize acts of terrorism. And that is why states usually are involved only at the initial part of the terrorist act and are responsible usually only for the omission. And anyway, states may be responsible on only using the norm of IHL and use of value, especially referring to the act of aggression. And you also said that if it's the act of internal terrorism, it's the internal law that has application and it has nothing to do with international law. So my question is then, how would you assess the case of seizing of Roman Protasevich? I'm sure that you heard about this case. In May 2021, Roman Protasevich is the Belarusian oppositionist. He was on board of the Ryanair plane that was flying from Greece to Vilnius, and the plane was stopped when he was above the territory of Belarus, but just about to fly into the above the territory of Lithuania. The plane was stopped because there was the information coming from the territory of Belarus that there is a bomb on board. There was no bomb on board, but the Belarusian authorities just wanted to make the pilots land in Belarus. So the plane turned from nearly the Lithuanian border to Minsk. The plane landed in Minsk, and it landed. The Roman Protasevich was arrested, and the plane was allowed to fly farther to Vilnius. And my question is, how would you assess it? Wasn't it the case of a state terrorism? And I don't think you can say that it was just the internal act of terrorism, if it was active state terrorism, because it was not just the problem of one state, as the Ryanair plane that was involved was actually registered in Poland. It was flying from Greece to Vilnius, and there was on board there were passengers from many other states that potentially were endangered. So I think that this is more international case. And I also have a second question, as it is always very interesting in the context of hybrid threats, and it's also always curious to me in the context also of disinformation. You mentioned deepfake. So how would you assess it in the context of international law? Is deepfake legal or not when it comes to international law? And if you are unable to assess it now, I understand this is very complicated and multi-level issue. So what would you say, which regime of law, which set of rules at least would be applicable to deepfake? Which set of norms could be applied to assess this phenomenon? Thank you.
Thank you. Comments and questions as well. If I understood correctly, there are two questions, and it is always easier to answer the latest one. So deepfake, I don't think that international law can have norms on deepfake. So in this respect, I think that it is rather domestic law, which should be applied if it needs to be applied. I also brought us, I think that it is rather just a complementary asset for terrorists to use deepfake, because in itself it's not really dangerous. It's rather just in the connection of disinformation or fake news. In itself, I don't think that it is the terrain. It is the domain under the domain of international law. And which jurisdiction should apply there? I'm not sure, because it happens on the internet, of course, and it can be determined on the base of the server or the location of the server. I'm not really familiar with this issue. As per the other question concerning Belarus, I think that empirically, I would say that this is part of a terror state, that you cannot really escape from the authorities, and even a plane would be forced to land, and you will be dragged from the plane. I think that this could be part of state terrorism empirically, but legally, I would say that this is rather a human rights violation. And as per the aspects of the Ryanair, I would say that I'm not an expert on the law of aviation, but I think that it would be just a normal internationally wrongful act, maybe, but not as serious as, for instance, aggression or terrorism, in my opinion.
Thank you.
Amnon, you raise your hand.
Yes. I just wanted to make a brief comment with respect to the conversation so far. So I want to touch upon 2 points that were raised. The first is the limits that Zeno talked about, the limits of humanitarian intervention broadly defined. So whether it's during war or not during war, so I totally agree that as international law currently stands, a state cannot simply say to itself or to the rest of the international community, oh, I think some grave violations are happening in my neighbor state, and therefore I'm going to intervene by sending physical presence or otherwise violating the sovereignty of the other state. But I think that the opposite is equally problematic. I think that if, let's say, and I know that I'm being hyperbolic here, but if, let's say, I know as a state that next to me there's a crime against humanity and the United Nations doesn't do anything. The United Nations Security Council is busy, or there's a veto right that is being exercised, veto power that is being exercised, and they don't do anything. I'm not sure that we can say that the state that knows that there is a crime against humanity going on next to it doesn't have, at that point, I'm not saying a duty, but at least it is relieved from the shield of sovereignty. And if it will intervene in order to stop this crime against humanity, whether later on the state which sovereignty was interfered with can go to an international tribunal and say, why did you do that? You shouldn't have done that. I'm not sure. In fact, I think the opposite. I think it would be stopped from doing that. Now, I do think that that you're right, that there's something missing here. And that something missing, so there is a national level that we talked about before, that jurisdictions do have a role with respect to threats that emerge from other jurisdictions to their own jurisdiction. This is what we talked about before. But they also have a role with respect to threats that remain in that jurisdiction, but implicate the international order as such. And the answer to that is not that each state can violate or intervene, to borrow from humanitarian intervening, but it doesn't mean that only the UN can or the Security Council can. I think that if there is development, and you end, Zeno, your paper with a call for new regulation, but you seem to take for granted the institutional dimension. You just talk about the norms and not the institutions. So I propose to you to also include the regional dimension. So we have regional international courts that can, the EU is an example, the EU courts, that's an example. You have in the Americas, you have, as we all know. So I'm not saying that everything should go only to the ICC or to the UN. That's the institutional point. You seem to also suggests that the ICC is more objective. I'm not sure whether you're making it as an empirical claim or a normative claim, because empirically, not sure about that. I don't know if we have enough data, I don't know. But even conceptually, I'm not sure whether we want this removed court. Because again, the idea of the rule of law, part of the idea of the rule of law, which your paper doesn't touch upon, is that whatever interpretation a judicial body, and again, I'm not suggesting that the courts are the ultimate answer. I said what I had to say about executives, and we can continue this debate offline. But to the extent that the courts are so essential, then a key part is that courts, when they develop their own interpretation, are then subject themselves, the judges are subject themselves to the norm that they develop. Now, if a court is too removed, and the judges then say, well, these are the laws that I develop for these situations, knowing that in my jurisdiction, the chances that I will ever have to confront this are low, there is a problem here. It's always also an idea. This is why I'm talking about the regionalism. If it has a regional dimension, it's better that it is dealt with at the regional level, because having a court too removed is also not a good idea, because this undermines a different aspect of objectivity. Last, and then I will I think that the missing part that I was trying to talk about before, and it was dealt with by the Tallinn manual, and the question is whether technology brings with it something different, right? That's what I started with, disruptive technologies. What is different about technologies than any other forms of terrorism? Because the international law has been dealing with terrorism and how to define terrorism and which institution should do what for quite some time now. The question is, what difference does technology make? And I agree with you that disruptive technologies do make a difference. But I'm not sure that your paper, as it currently stands, is sensitive enough to technologies when it talks about the law. So maybe if you go down into the idea that these disruptive technologies can ultimately disrupt the very notion of democracy, then we have something to talk about. But then maybe intervention is more, something the international law should be revised at the normative level or the institutional level. Which institutions? Only the United Security Council? I don't think so. Maybe others as well. But also with respect to the norms, under which conditions should we intervene in other jurisdictions because of the technology? Because the technology somehow changes the relationship between the self and self-determination, the citizen and the ability of the citizenry to self-determine. So if technology disrupts the ability of a jurisdiction to self-determine and exercise self-determination, then it influences the notion of sovereignty. Then it actually changes the way we should think about international law more generally. And therefore, there's something unique about cyber terrorism, which is interesting. Otherwise, okay, we have just this weapon or that weapon, but the laws should remain the same. That was what I wanted to press you a little bit on.
Thank you very much. Now I have my topic for the next year's session.
Okay. See that we have no more internal questions, then I will allow myself to ask a question. You talked about the fact that state terrorism is mainly internally. What about state-sponsored or states' support of terrorism against another state? We've been talking about that ever since US and Libya, for example, and with the ICJ decision in that context. But it has been going on. Today we have a lot of talk, especially in our region, about Iran's responsibility over terrorist activity, but it's not the only one. And also ISIS, which could or could not have been identified as a state at certain points, operated outside of its border, but it was a state terrorism activity in some sense. So I wonder why you refer mainly to state terrorism in the internal aspect.
So what was the question itself? Because I understood your standpoint. I missed the question part, sorry.
That was the actual last sentence. Why do you refer necessarily to state terrorism as the internal aspect of a state versus its own, either citizens or within its own territory?
Okay. But because I made a differentiation between internal state terrorism and international state terrorism, and I think that state-sponsored terrorism, like for instance in the case of ISIS or Iran, I would say that from my eyes it seems like aggression many times. The question is whether it's attributable to the state. If the support or the sponsorship is in an advanced level, I would dare to say that it is attributable to the state, and if it is against another state's sovereignty, if it is against the population of another state, I would say that for me it would seem like aggression. So this is why I did not tackle it separately, state-sponsored terrorism in an international level.
It really depends on what the actions are, because not every act against the state sovereignty necessarily constitutes act of aggression. So, and it also depends what is the level of support that the state has towards the non-state actor operating against a third state. So you have different levels there of control or support between the state and the non-state actor actually doing the terrorism, and also the act of terrorism. There might be some differences between what constitutes an armed attack sufficient, or the use of force sufficient to constitute act of aggression. And in order to make, you get the idea. There is a spectrum there, and I'm not sure that it's that clear cut between what the state is doing and the actual outcome to say that if it's international, it has to be an act of aggression, and if it's internal, I think there was a point that Amnon made that why do we need a definition of terrorism? We have enough violations under international human rights law that we don't really need an act of terrorism internally. We have enough problems without it.
Mm-hmm. As the first part, now I reconsider my rather extremist opinion, because I was thinking about the Nicaragua case as well, because the involvement of the USA was rather high, and it was not attributable to the state, and it was not considered as terrorism or aggression. So I agree with you in that respect, so you convinced me. As per whether it is necessary to label autocracy, to put it simple, as state terrorism, I'm not so sure that it is the labeling which is relevant. But my point is that even if we call it just human rights breaches of human rights, or systematic breaches of Youth Kogan's norms, I don't think that as of today the international law provides enough help to tackle these problems. So I'm not really convinced that human rights can really protect those ones who are under an autocratic regime. So it's not important for me whether we call it state terrorism, internal state terrorism, or we create a new and more effective human rights protection regime. But the point is that I think that today the international legal order is not ready to tackle the massive breaches of human rights in a systematic ways like autocracies do so.
And even if you take the Rome Statute, there are very, very significant limitations of its jurisdiction. So even if a state might be violating, even if we had a crime of terrorism, even if we could actually accuse a state of act of terrorism, internal terrorism, most likely that state would not have been party to the Rome Statute.
One very important stipulation here is that the International Criminal Court would never assess states for the crime of terrorism, because it has jurisdiction only on private individuals. Concerning the ICJ, for instance, again, it's not really the forum or the labeling which matters, because I don't think that the ICJ is an adequate forum, for instance, for assessing human rights violations, although it may be a possibility, but I'm not really convinced that it is an option. Again, I would say that the problem is that international law cannot protect civilians against its own state apparatus or state regime.
But, well, we are in a better situation that we were in the 1940s, I think, in that sense. Okay, I see that we have a question from the audience, so I will ask it and you decide if and how you want to respond to it. Shmuel is asking, according to you, Zeno, how humanitarian intervention can help to reduce terrorism and terrorist activity? Okay,
humanitarian intervention cannot help because this is an unlawful practice, and it cannot help to prevent or to oppress terrorist actions. So another kind of intervention may help, but as of today, it can only be ordered by the United Nations Security Council, I would say so. But I'm not sure whether it's always the military action or the military intervention which can help in this regard.
Thank you. I see Kaya wants to ask a question. Please.
Yeah, just a follow-up question. And what if the humanitarian intervention is in a state like Somalia or Libya or Syria? Well, maybe not Syria, but fallen states without state organs controlling territory and with people dying. But what's your position on that? Because I see you have a strong position on illegality of humanitarian intervention, but there are different models of humanitarian intervention that we can imagine. Maybe they won't happen in reality, but what in that case? What would be your, and let's suppose that those groups are terrorists like Islamic State in Somalia or Libya.
I just want to very briefly join here. I will have to leave in a second, but consider also in cyber, humanitarian intervention or intervention doesn't necessarily have to mean that you send troops, boots on the ground. You can use cyber from your own territory, but in a way that undermines state control or state terrorism or however you want to say that, on cyber, totally on cyber, right? Without what you're talking about, right? And then you consider Syria in the example that was just, and so it's more complex than could be more complex than your bright line, what is lawful and what is not lawful.
Okay, but I would say that humanitarian intervention will not be lawful, it will not be legal, but I'm pretty sure that in these cases, those states will not be held accountable and responsible. And it should be like that. So it will be an illegal action. I'm pretty sure about that. But this accountability will not be present in any courts, and these states will not be accused of aggression.
So it would be illegal but lawful, or not lawful but legitimate, like Kosovo, right?
So. Yeah. So I would not say that this is lawful, but it is acceptable and legitimate, and no one will challenge this notion. But it is still illegal.
Then would you comment that kind of humanitarian intervention? Would you be in favor of this kind of humanitarian intervention? Because sometimes we try just to label something legal, illegal. Weed is illegal in Poland and in Netherlands is legal. This is very subjective, right? Here we are talking about much more important topics, but legality is not always something that we are looking for in rule of law.
Yeah, well, I think that afterwards we are always really clever and we know that this was a mistake to intervene, or yes, it was a really good thing to intervene. But I think that there are situations when intervention is absolutely needed, even if it is illegal, even if we do not know whether the intervening state would abuse this situation. There are times when we just have to accept that there is no other way than the ultima ratio to intervene to a country's home affairs. So again, I would accept, as a person, not as a lawyer, of course, I would accept such intervention, but I would not write a paper about how unlawful was it, because I'm concerned that it will be unlawful, but I will support such an intervention.
Okay, thank you.
Thank you.
I have to say that I do like your caveat of as a person, not as a lawyer. Justifies a lot of what we think about lawyers generally. Leah, you have a question.
Yes, I totally agree with you, 100% on the unlawfulness of humanitarian R2P, responsibility to protect humanitarian intervention. And I say that as a Canadian. I think if you want to shore up your position in your paper, it might be just worthwhile to spend some time talking about the principles of sovereignty and non-intervention and how it degrades that, and just kind of root it back into some of those core principles of the rule of law, international law, and say, while it may be justifiable, if not legal, that it certainly is unjustifiable in the sense that it breaks down kind of the quality of sovereign equality of states and whatnot. So if you spend a little time there, you might be able to just shore that up. That would be all I'd say, because I do totally agree with you.
Thank you very much. Really, really useful comment. Thank you.
I think that actually concludes our discussion on Zeno's presentation. I want to thank Zeno again for a very, very interesting and thought-provoking, as you can see, discussion. I want to thank Amnon for his response. And yeah, and that's it. I think we're going to take a 20-minute coffee break before the next presentation of Leah.